2, seizure memos. Number 3, documents. Number 4, charge sheet and other documents which the prosecution has relied upon as per the list of documents mentioned in the charge sheet. Let the said report be filed before this court by the learned additional session judge on 18th of February 2025. The petitioner and the department as well as the petitioner is directed to communicate this order to the learned additional session judge for compliance.
So 2 reports have been. May I get some precedence? Let it appear at 2 p.m. or at fixed.
I will take. Let the report filed by the state be kept with the report.
May I get a copy of the report?
Let the court consider that.
Any date has been fixed. Yes.
18th February.
I'm good.
एक ध्यान देना, इसको भेजना डिपार्टमेंट से भेजना है. Next.
I appear for the petitioner. I'm being led by Mr. Jishnu Chaudhary. Is on his way, Malad.
Yes, sir.
I'm being led by Mr. Jishnu Chaudhary. Is on his way, Malad. May I start? Malad, this is the writ petition challenges. Malad, may I file the affidavit of service? Personally. One second. We've served on the respondent, Malad. This is a matter, Malad, where I have challenged the declaration of my clients as a willful defaulter by the bank. The answering respondent is the Canara Bank, Malad. We've served notice, even after mentioning we've served further a notice. Yes. They had appeared also on the last occasion, I'm told, Malad. There's an order, Malad, had passed on the last occasion.
Malad, I appear for respondent number 1 to 4, Malad. Malad, on the last date, we had requested them for serving us a copy of the legible copies of the annexes to the writ petition, Malad. Malad, till date, we have not been served with the legible copies of the annexes.
Yes, why you're not served?
That's been served, Malad. My instruction.
Legible copies are.
Malad, we'll kindly see the last affidavit of service.
We have sent them an email on 2nd January, Malad, when the matter was last listed.
Email 2nd January.
Give the copy.
We're giving the copies, Malad. We've already given. I'll just, Malad, will grant me 1 minute, Malad. But I'm being told that they've been served, Malad. The affidavit of service is also there, Malad. We'll give another copy if required, Malad.
Scan copy or better than.
May I just place the facts of my case, Malad? Here, the question, it's their documents that I'm relying upon.
Where is the impugned order?
Yes. The impugned order, 28th October 2024, page 561.
25.
Yes, Malad. 30th August, I'll come to later, Malad. 28th October 2025 is the main impugned order.
Yes.
Malad, will kindly come to page 561. Before that, may I just place the facts, just the dates, before Malad opens the brief. Malad, here, the only relevant dates for a willful defaulter matter is, Malad, whether show cause notice was issued to my client, because this is civil. Malad knows, JAR developers is very clear, this is severe civil consequences. I will be debarred effectively from taking any credit facilities from any bank. Show cause notice, Malad can only note the dates. Show cause notice issued on 8th August 2024. I reply to the show cause on 24th August 2024. They write to me thereafter on 25th September 2024 asking me for further documents on the basis of my reply. So my reply is there. They say that please provide me with further documents. They grant me on 25th September, they grant me 15 days to provide these documents. I do so within time. But suddenly, out of that period, now, Malad, in that consequence, 25th September, they ask for documents within 15 days. I provide those documents on 5th October. Thereafter, Malad will kindly see 28th October, that letter. Page 561, they say the notice issued to notify identification committee on willful defaulters, and the bank has decided to classify the company borrower so-and-so as willful defaulters. 561, Malad, that's in volume, Malad, volume
Yes.
4. All the documents I'm relying upon are all in volume 4 and 5. 28th October, they say the notice issued to notify the identification committee on willful defaulters of the bank has decided to classify the company borrower as willful defaulter and pass an order on, Malad will kindly note, 1st October 2024. This is prior to even expiry of the period that I had to submit those documents. So they do two things. Number one, they ask for documents within 15 days from 20th September 2024. That expires sometime in the middle of October 2024. I comply with their request and provide them with documents on 5th October 2024. But they write to me subsequently saying, we have passed the order on 1st October 2024. ex facie, my lord, malafide is number one. Secondly, non-application of mind is writ large on the record, my lord. This is Canada Bank. Number
Yes.
256. My lord, may I have my lord's leave, my lord? Mr. Chaudhary is leading me.
That same subject matter, same law. Done. I also now will not start laughing when this happens. Will not just three things. Number one is Milord, volume 4. Lordship has seen. Milord, the show, please see the show cause, Milord. A lot of Milord statements in the show cause notice. The more you say, the more documents you have to give me. Response, Milord, is 547 in volume 4. Yes. Volume 4. Hard copy. Oh, yes. Yes. It is, huh? Starts from Milord 532. I don't think that volume is with the quote. Milord, please have a look at page 547. Paragraph. This is what? Reply to the show cause. Reply to show cause. Reply to the show cause. Earlier show cause. No, Milord. The show cause is at page 527. It is dated. No, then 561 is another show cause. Milord, 561. 561 of 28th October 2024. No.
That's the order.
That's the order of the identification committee, Milord. This is the first thing, Milord. In chronology, Milord, show cause is, Milord. Show cause is where? Yes. Dated 8th August 24 at page 527. This is the first, Milord, document. First show cause. Yes. And dated, Milord. 8/8. 8/8/24. Correct. Then you give the
Milord,
reply on 24. Detailed, Milord, show cause referring to 100 documents maybe. Milord, which are not given to me. I respond at page 547. Milord, at 532 starts. Starting at 532. Yes. Starting at 532, Milord. And 24th August 2024. Correct. And I want to show your lordship, Milord, 547. Subparagraph G. It is preposterous and unfathomable that an institution of your repute has proceeded. Yes. G, Milord. Yes. Identify accounts of the company as willful defaulter without relying on any documents as such. It is mandatory to rely on certain documents and share with the account holders the same while issuing a notice for identifying the account as willful defaulter. Next paragraph also, Milord. Quintessentially important part of identification proceeding to refer and share with the borrower and or account holder the documents on the basis of which the opinion was formed. Yes. Now, Milord, please have a look at, Milord, I'm omitting that they asked me to come for a hearing, I asked for an adjournment, document, etc. I am just now straight coming, Milord, to page 561. Yes.
ওটাতে আসছি। I'll come to that. The absurdity, my lord, beyond belief. My lord, please see, my lord, 561.
Yes.
Notice is issued to notify the identification committee on willful defaulters of the bank had decided to classify the company and has passed an order on 1st August 24. Extract of order is annexed.
1st October.
October.
Yes, my lord, 1st October. And please see, my lord, the next page. Extract of the order of the committee. So extracting, my lord, the portion which relates to this. We have issued show cause notices, duly informed the charges. Borrowers, guarantors have responded. Opportunity of hearing provided. Committee has not satisfied with the submissions.
Yes.
Decided. And with not a single reason. Not a single reason. Now, my lord, from this, so two, my lord, infirmities. Number one, no documents provided with the show cause notice.
Yes.
My lord, the several orders, my lord, which I refrain from citing, your lordships have always held. If you give a show cause, intrinsic part is to give documents or provide inspection, without which you can't proceed. Here, my lord, neither do they give documents nor do they provide inspection. On the other hand, they ask me for documents, my lord. Please have a look at page 57. This is before the order. You know, this is a classic. With reference to the caption subject, our letter reference such and such, your reply such and such, personal hearing held with such and such, on such and such attended, we request you to submit the details. 1, 2, 3, 4, 5. Now they want documents from me. And which means that there's no satisfaction on their part. They have to give me the documents. Now they want documents from me. And what my learned friend, my lord, is emphatically saying.
So you are given the document of this as per the page 557.
Yes.
Have you supplied this document?
Yes.
By which letter?
Supplied. Answer the question.
558.
Show me the page number.
558.
Next page, my lord.
558.
Yes, my lord. 5th October. Next page.
Reply 558.
Yes.
Dated 5th October.
Paragraph 3. Pursuant to the additional information requirements stipulated by you, vide this notice under reply, which was not part of your earlier show cause notice. We would like to submit. Tally backup has been furnished by us to forensic auditor. Accounting system can be accessed by lenders anytime during office hours by giving prior information about the visit.
Yes.
So this is the response. Now, my lord, if your lordship comes back to 557, previous page. My lord, please see, my lord, 3rd paragraph. Hence, we request you to furnish the details sought within 15 days from the date of personal hearing, that is latest by 9th October 2024. Order, my lord, is of 1st October.
Yes.
So 25th September, you say that I need XYZ. I tell you, come to my office and take it, inform me. You say that I'm giving you till 9th October. But before that, on the 1st of October, you pass an absolutely unreasoned order. And then, my lord, we thereafter file page 563. The my lord, appeal representation
Appeal to review.
review committee.
Yes.
And my lord, please see 614. Review committee, last paragraph, page 615. Review committee have assessed the facts, material on record, including representation, and has decided to declare the borrower. My lord, not a single, my lord, reason given.
Yes.
So, my lord, if I may go back and summarize make the 4 points and refrain from citing judgments which I have cited earlier. Number 1, no documents with the show cause notice. Number 2, in spite of request for document, no document handed over. Number 3,
Yes.
formation of opinion under severe doubt because bank itself wants more documents. Number 4, order of my lord, the identification committee is without reasons, non-application of mind and violation of natural justice. Because my lord, when there is an appeal, you have to give reasons. Otherwise, what will appeal court do? And number 6, even the appeal court doesn't, my lord, choose to give reasons, my lord, review committee. And my lord, number 7, the most severe of all, my lord, inconsistencies. My lord, the identification committee gives me, my lord, time to give them documents. And my lord, even before that, disposes of the matter. It's the matter.
Yes.
My lords, may I pray to be kept it on Friday, my lords, of next week. I'll physically be there to submit the arguments, my lords. My lords, my learned senior friend has placed upon 6 arguments, my lords. I'll precisely make my submissions on the next date and complete my submissions, my lords.
Oh, I know Mr. Mohapatra. He is from Odisha. I have met him at the NCLT in Odisha.
My lords, I'll limit my arguments, my lords. In fact, I'm being led by Mr. Ratnanko Banerjee also, my lords. I have sought for certain documents from them also in relation to the legible copies of the writ petitions. They may be served to us. I'll limit my submissions on the next date, my lords.
No, I can't do these things.
Counsel for the petition has concluded his argument. Full stop. Counsel for the respondent prays for time. According to the John, let the matter appear on 11th February.
Grateful, my lords.
My lord, I just request my learned friend, my lord, not to me given under assurance or undertaking in writing, but to my lord only tell your lordship he won't start off any criminal proceeding.
My
in
lords, my lords,
7
I
days.
oppose to that, my lords. I oppose to that submissions, my lords. If my lords, my friends are permitting, my lords,
I
am
am
ready
not
to.
asking, Mr. Mohapatra, I am not asking for an interim order. I am requesting you not to do anything for 5-7
Yes.
days.
My lord, this company has been defrauded 13 banks, my lords. I'll make my submissions on that fact, my lords.
Then if you are not adhering to that, then I will not give the adjournment. Then you continue with the argument today itself. You are taking one time from here and you are taking the action against the petition.
No, my lords. My lords, already there is a CBI complaint that has been lodged by the bank.
That is fine, but don't do
I
anything
am
more.
not saying all these things, but no further action.
Very well, my lords. Very well, my lords.
No
I'll
further action be
I'll
taken
inform to my clients on that.
from today
Yes,
onwards
please in.
till the next date of hearing.
Which are the next 2 months? And Lord, 54 and 55 are also, my lord, similar matters. Oh, and more problems.
But these are all separate. Main petitions are same.
I am taking, don't worry. I am
Lord, he has run,
taking now.
my lord, he has run away
He
with
was
my cricket
driving me
kit.
from
I have a match tomorrow. He has run away with my cricket kit.
But what will he do, my lord? He doesn't have time to play now, my lord.
He will-
Always play.
He will take the brief in the cricket ground also. When he will be in duck, then he will start treating.
He's a better sports person, my lord, as on the date, my lord. Even he's senior to me than me.
One of my first juniors.
My lord, he's 8 years, my lord, elder to me, but with more fitness, my lord. I don't have.
There's a reason behind his fitness. Lordship need not even think on those grounds. There's a reason behind the fitness. He's run after, my lord, too many people in his life.
Now he is complaining that you are not taking him out.
He doesn't need me to take him out. There are people who can take him out.
You come to Calcutta, I will take you out.
I am in
Yes.
Calcutta very much.
Oh, this is Mr. Chatterjee.
Chatterjee.
No. No, worst thing. Yes, I am suffering for 30 years. No. I retract. I don't want anything to do with him.
That's why I told him
I thought it was Mr. Mahapatra.
Well, that's what I'm saying.
Let's-
He
Lordship, it's the
run
next
after
item.
too many people.
My
He's
lords,
quite big.
before the
No,
next
no,
item is taken up, my
Next item, I'm led by Mr. Chatterjee.
My lords, before the next item is taken up, may I pray, my lord, this
47, your
item
lordship.
46, my lords, be fixed on a particular time, my lords, so that my learner senior maybe
47, your lordship.
46. You're
Well, it's
right with 46.
46.
my lords,
I
let it be
I can't fix, but it will be on that day.
Yes. And we'll wait for our turn for 54. It will come, Lord.
Yes.
Below the next matter,
नहीं आया तो नहीं करेंगे
below 40.
रहने दो ऑर्डर मत करो
खत्म
कर
देगा तो
ठीक Yes, item number
47, your lordship.
come tomorrow.
Your lordship, your lordship, actually the petitioner before you lordship are very poor farmers. Your lordship, poor farmers. The ECL has flouted a scheme. According to that scheme, the petitioners were to provide their land, and in return they will get employment. They were asked to file a report. In that report, they have denied the existence of the scheme itself only, your lordship. Your lordship,
You take the land.
lordship, they have registered the land in their favor. Lordship, mutation certificate given, possession certificate taken, lordship.
Yes, Mr. Chatterjee, you file the
Later, my lord, we take back the land. We'll take back the land.
yes, you take back the I am passing in an order giving liberty to take back the land. If they have taken out the scheme, then you take back the land.
Because it's a malafide thing. Beloved, what happened, beloved, if your lordship remembers, they had, beloved, do I come back on Monday?
Yes, come on Monday. It will be
Yes,
May I file the report for the ECL for you?
Oh, yes, certain precedents, lordship.
original
I'll
site.
come back on Monday.
Yes.
Lord, before your lordship is shifting to original side, my lord, may I just indicate, my lord, item number 57 of your lordship's leave, my lord, kindly appreciate, my lord. This is a matter pertains to, my lord, freezing of bank account, my lord, on 13th of January. My lord, my other side is also present before your lordship. My lord, considering the urgency, your lordship was pleased to fix the matter on 22nd. My lord, every day, my lord, the matter is, my lord, if your lordship,
Monday it will be up.
if your
because
lordship
we are
kindly
reached
fix, it's a
46.
matter of 2 minutes only, my lord.
Sir, today already we are reached 46. Now 50,
My lord,
56.
everyday matter is, my lord, descending.
So what do you want?
My lord, to fix a time, my lord,
100.
to fix a time, my lord, if your lordship kindly take up
Okay,
this matter, my lord.
let the matter fix on which April, which date is vacant. As per the prayer made by the council for the petition, let the matter appear on 3rd April at 3 p.m.
My lord, 3rd April, my lord, it's, my lord,
No,
Lord,
you are
my
not
business is
understanding the
closed,
court's position. I am telling that it will be remain in the list from on Monday.
your lordship pleases.
This may remain here, not to disturb. Huh? Yes, original side.
Lordship, original side. Lordship, original side mentioning
I'm
Lordship, may I
opposing the
mention
mentioning
item number 28 of your Lordship's list? This is a review application from a decree passed by your Lordship in a summary suit. Lordship, the urgency is in the execution code. Lordship, we have already been directed and we have submitted half the amount. Now the balance half has been directed. Lordship, only humble prayer is item 28 is the review application. Any day convenient to your Lordship, the execution is posted on 2nd of March. This will take 10 minutes, your Lordship. It's on a technical point of law. If your Lordship is convinced,
Sir,
otherwise, your Lordship, I will have to suffer whatever it is.
well, I'm opposing this prayer, Millard. There is no such urgency, Millard. In December 16, Millard, they were directed to deposit. They have deposited.
Yes.
Yesterday, Millard, they have again directed to deposit. Millard, it will be in the registrar original side, Millard. They will secure the amount in a nationalized bank, Millard. Millard, there is no such urgency at all, Millard. They tried to stall the execution
No,
proceeding
Your Lordship, if I
by
would
the
have,
hinges
first of
of
all, I
the
would not have
petition.
deposited the amount.
But what is the what is the review point? What is the point of review?
Lordship, point of review, your Lordship will recall order 37 suit.
Ah.
Your Lordship, there are two summons to be carried out. One is summons for judgment and one is writ of summons for appearance.
Correct.
Now, your Lordship, it is my case that they had only carried out one summons. The summons for judgment was never carried out. This is the limited point.
Because they, Millard,
And your Lordship
failed
had
to
heard
appear
it, your
within
Lordship will
10 days,
remember.
Millard.
Lordship, I
failed
have
to
come
appear
up for
within 10
review
days,
because
Millard.
your Lordship, it's order 37, only that point. 5 minutes any day convenient to your Lordship because I've already deposited.
See my diary.
No, I appreciate. I am aware your Lordship has a heavy diary. That's why I'm not. Lordship, it's my humble prayer. Any day, 5
There
minutes.
is no such urgency, Millard.
Grateful, Lordship.
Yes, next.
I am for the 1 and 3 petitioner.
But I'm for the respondent. I'm the petitioner in item number 2, my lord. This has come up for correction.
Yes. No, actually the date 2nd March, it should be a 3rd March. That's all.
That's okay.
5th March.
Very well. Grateful, my lord. Grateful,
My
my
lords,
lord.
my lords, regarding this matter, I also appeared for the petitioner item number 4. My lords, there were also two appellate side matters which were tagged along with these 4 additional side matters.
Also be on 5th and 5th and
3rd and 10th, my lords.
10th.
5th and 10th.
By mistake.
My lord, the orders have not been passed on those matters, my lord. 16737 and 16746.
Come before the appellate division.
My lords, I'll mention on the next date, my lord. Then. Grateful.
The matter is listed as to be mentioned for correction in the order dated 27 January 2026. In paragraph 4 of the page 3, paragraph 4 of the order, this court has fixed the matter on 5th of March 2026, but inadvertently is recorded as 2nd March 2026 at 3 p.m. Accordingly, in paragraph 4, the date shall be read as 5th of March 2026 at 3 p.m. instead of 2nd of March 2026. This order be incorporated with the order.
Grateful, my lord. Grateful, deeply obliged.
Grateful, my lord.
Yes.
Back to the patent.
I'm for the respondent number 1.
Last occasion, if you recall, I had attacked claim 4 of the application for patent. Because also kindly take claim 4.1 at page page 107 and 108. 107 was the amended claim and 108 was the original.
Claim 4.
Yes, my lord. Claim 4, if your lordship recall, there was a question of the amendment of that part of the excipient. And the excipient was removed for an injection. Therefore, the question was that how can something in a powder form act as an injection?
Correct.
Lordship. Therefore, if your lordship kindly takes 108 first, claim 4, the third line, along with pharmaceutically acceptable excipient. Claim 4, 108. 108.
Correct.
Lordship has it, my lord?
Yes.
This is the original claim.
Claim 4.
Yes, this is the original claim. Along third line, the process of claim 1 along with pharmaceutically acceptable excipient. Well, this excipient can be anything like saline water or distilled water for the purpose of making it into an injection. Because if your lordship sees,
So that was deleted.
yes. Now, if your lordship
This was the original claim.
this was the original claim, and page 107. If your lordship takes page 107, claim 4 has amended a pharmaceutical composition for treatment of iron deficiency by
the process as claimed
by parenteral. Parenteral administration means an injection.
Yes.
Comprising more than 90% ferric chloride. So the excipient has been removed.
Correct.
Now, once the excipient has been removed, there cannot be an injection. That was my submission. But on that point, write a judgment more on a basic patent point, and this is one of the older judgments, one of the first few judgments. The Supreme Court judgment, your lordship kindly takes paragraph 16 on.
Yes.
Yes, sir. Before dealing with paragraph 16. Before dealing with these contentions, let us have a general idea of the object, the relevant provisions, and scheme of the Act. The object of patent law is to encourage scientific research, new technology, and industrial progress. Grant of exclusive privilege to own, use, and sell the method or product patented for a limited period stimulates new inventions of commercial utility. Not to be kindly note, new inventions of commercial utility.
Correct.
The reason I pointed out, the reason I stress on commercial utility is that an injection in a powder form can never have commercial utility. The price of the grant of the monopoly is the disclosure of the invention at the patent office, which after the expiry of fixed period of monopoly passes to the public. Now, my lord, very important. Paragraph 18. The fundamental principle of patent law is that a patent is granted only for an invention which must be new and useful. I stress on useful, apart from the fact that this is not new. That is to say, it must have novelty and utility. It is essential for the validity of a patent that it must be the inventor's own discovery as opposed to mere verification of what was already known before the date of the patent. Now, Lordship will finally take paragraph 21. It is important to bear in mind that in order to be patentable and improvement on something, your Lordship recalls this application was for an improvement of process of ferric carboxymol of manufacture of ferric carboxymol. To be patentable, an improvement on something known before or a combination of different matters already known should be something more than a mere workshop improvement and must independently satisfy the test of invention or inventive step. Well, in my humble submission, none of this has been met. No invention, no inventive step. I will go one step further to say this was not even a workshop improvement.
Yes.
To be patentable, the improvement or the combination must produce a new result.
Correct. or a new article or a better or cheaper article than before. Well, the article out here is useless in my humble submission. It is not even an article which can be used. Yes. After the amendment, that is. The combination of old known integers may be so combined that by their working interrelation they produce a new process or improved result. Mere collection of more than one integers or things not involving the exercise of any inventive faculty does not qualify the grant of a patent. Well, only for this part of it, I am submitting that the basic law, basic patent law, basic scope of the Patents Act is that it has to be an invention. It has to be something new, and if it can be.
Correct.
Can be
As per your submission, after the amendment, it cannot be new.
Cannot be because it is useless. There is no utility.
Okay.
There has to be a utility. But in this backdrop, your lordship kindly takes
ये मानो तो इनको निकल गया.
your lordship kindly takes note of one thing. This patent that has been applied for is a combination of ferric fluoride and sodium hydroxide, which makes it ferric hydroxide. Now, the ferric hydroxide, once this is according to the patent application, once it is mixed with a maltodextrin and citric acid, it is apparently coming to something called ferric carboxymaltose. Now, the maltodextrin is a form of starch.
What would be the effect?
That is the thing. It is a form of starch. Now, for it to come to this ferric carboxymaltose, this starch has to be oxidized with an oxidizing agent. What is being used here, along with the maltodextrin, is citric acid. Citric acid is not an oxidizing agent. And this has been referred to by my learned friend. Their reply. Or their rejoinder. Lordship was trying to this was relied by my learned friend, page 265, in their rejoinder to our supplementary act.
$265.
260.
Yes. Citric acid.
They had annexed a book.
Correct.
Seven volumes. This will probably be in the second volume, volume 2 of the.
Yes, got it.
Your lordship has this one.
Yes.
The heading being citric acid monohydrate. If your lordship kindly take point number 6.
Functional category.
Functional category.
Yes.
Acidifying agent, antioxidant. Therefore, it cannot be an oxidizing agent.
Antioxidant.
Yes. So citric acid is not an oxidizing agent, which is necessary
Yes.
to come to ferric carboxymaltose when added to a starch, which is in this case maltodextrin. And Lord, this is, if your lordship kindly takes annexure I.
Annexure I of
my petition. Okay.
But I'll take your lordship through that later, my lord. Therefore, my lord, citric acid is not an oxidizing agent. Therefore, the patent should not have been granted because this is misrepresenting, which is barred under section 64. And my lord, I have this. Lordship kindly takes the book, my lord. At page 322. At page 322, my lord, 8.052. Okay. Lordship will kindly see. No.
Yes.
Under 64, under section 64(1)(j, the patent can be revoked if it was obtained by a false suggestion or reference. Such a ground would be available if either the applicant did not have right to the invention or if the applicant was barred by means of contract law, so and so if the invention was stolen. This ground would also be attracted if the description in the invention was itself misleading or misrepresentative in nature. And I say, my lord, this description was misleading, misrepresentation, because citric acid can never act as an oxidizing agent.
Patent can be revoked if it is obtained by a false suggestion
Or representation.
or representation.
And lordship will kindly come to that part where it says this ground would also be attracted. My lord, the last 3 lines of that paragraph. Last 3 lines of that paragraph.
This ground would be
also be
attracted if
the description in the
invention was itself misleading or misrepresentative in nature.
I say it's misleading because the citric acid can never be an oxidizing agent. I say it's a misrepresentation for the same reason.
Okay.
It is not possible because the citric acid, as the book says, my learned friend's disclosure, that citric acid is an antioxidant. Once it is an antioxidant, it cannot act as an oxidizing agent.
Yes. Okay.
Lord, and the last point. My learned friend have, Lord, I must admit, Lord, this is not part of the record, but this is available. This is my learned friend's application. This is available. It's their application and their patent. It's available in the public domain in the patent office website. Lord, you will kindly grant me to Mr. Mukhopadhyay to explain this part.
Application.
Page.
The page is unfortunately.
No, down there is a page number.
Internal page 26.
We claim
Yes,
that one.
So what you have is, I know in this particular pattern, which has been what we are doing is that say that they are making iron, supply of iron is given, that is very hydroxide. There are some steps in that. Very hydroxide they are taking microdextrine and then oxidizing with citric acid, get very carboxyl monoxide. Now, if my lord refer to this particular claim, It's talking about a process for preparing iron-free polymyxos complex. Right. Now, in this, step 1 is talking about the same step as in ferric hydroxide prepared by ferric chloride and sodium hydroxide sodium. In the second step, in step B, we are talking about same thing. Ferric hydroxide is being recorded, reacted with hydroxide and
Where from you are reading paragraph?
paragraph 1A.
Yes, 1A, preparing ferric oxide.
Ferric hydroxide.
Correct.
Then B, reacting the washed ferric hydroxide
Correct.
with maltodextrin
Maltodextrin, that is citric acid.
at a temperature of 62 or 120 degrees centigrade and a period of 6 to 12
Hours were maintained.
some temperature, some time while maintaining a pH and putting the reaction mixture and getting the. Now, interestingly, the same reaction scheme here is not giving a carboxyl molecule. It's completely differently iron polymyxos complex, which incidentally we are talking about the same competition as well as on separation. Yet throughout we are saying that once you use the citric acid oxide, it will cross-link and will go to some other product. And what this particular petition is subsequent to this particular revocation time, they are saying the same thing and got a petition.
But yes.
So that is representing the fact itself is misleading.
Okay.
In fact, it is so interesting to see that citric acid can be used as an oxidizing agent. It is very wonderful. That is that.
Therefore, the point is that the same reaction in this case is producing a different product, different complex complete. What we are talking about was the ferric carboxy model the challenge. It's the same thing. And here with citric acid becomes a completely different product.
And citric acid in the water.
Yes.
And
Completely
the
different product.
Correct.
Therefore, again it comes to the false representation and the misleading.
Okay.
But therefore, if I may just sum up. Number 1, this is a product by product. As I have shown your lordship, I have cited the judgment, the by-court judgment, and the guidelines. The lordship, this was 7.9 of the guidelines. It says for a product by process to be patentable, not only the process, but the product also has to be novel and new and unobvious. Unobvious. My learned friends have not crossed that hurdle. Number 2, the description and the example, the illustration, the claims completely different from each other. That is under section 10.4, the violation. Therefore, can be revoked. Number 3, the amendments allowed, and this goes to the controller as well. This is directed at the controller as well. The amendments allowed should not have been allowed because the amendments can be allowed under section 59 only on limited grounds.
Yes.
One of those limited grounds, clarification, whatever. And my lord, an added point the point I want to add to this is the controller, if your lordship recalls, has refused to file any pleading. Controller has said that we will file a written notes of argument. My lord, written notes of arguments are not pleading.
Yes, that is not.
They are not pleading. No, therefore, the stand taken by the controller in the written notes of argument, in my humble submission, should not even be taken into account.
Why?
Because the pleadings are affirmed. There is some level of responsibility taken.
Correct.
Written notes of arguments are not affirmed by the party. Therefore, it is not considered pleading that there can be a responsibility because it is given. But it is not affirmed. There is no verification in the written notes of argument. Therefore, points taken in the written notes of argument, unless it is made in the pleading, that is why, my lord.
Okay. So you mean to say what the written argument they have submitted, that is above the
I
pleading.
cannot go beyond my pleading.
Correct. That is
For
above the
example,
pleading.
even if I have to submit my written notes of argument, I cannot go beyond this.
That's why the written notes of argument is submitted.
It
What
is
you argued, assistance. What is
Yes.
in the plea? What is the case made of?
Which they don't have any pleadings to support their case.
So you.
Or to support the judge, to support the patent.
So as per your case, the written notes of argument which has been considered, that is above the pleading.
Yes. That is, and that is not what is mentioned in the pleading because there are no pleadings. Therefore, he's making a new case, if at all. If at all the controller files written notes of argument, he is making a new case complete.
Correct.
It's not a making of new case. I'm appearing for the controller, Your Lordship.
No, I'm on a different point. I'm saying that when there is no pleading on your
His case is that if you file the written notes of argument above the pleading which was not pleaded in your application, so that is a new case you have pleaded.
It is in the
So
act
that's
of
why
law
that portion could not have been considered by the control.
I'm grateful. That is my. Now the next point is the amendment that has been allowed by the controller. I showed your lordship claim 4 that the amended form could not have been allowed. In fact, it is perverse because at the cost of repetition, an injection cannot be there without an excipient in a
That
powder.
you submit.
Amendment of the claims.
And my lord, the last point that I mentioned today, the representation is false because citric acid cannot be inoculated. And my lord, all the judgments I have cited, your lordship,
Yes. I request my learned friend to just explain to the Honorable Court what is the difference between IPC, iron polymaltose complex, and ferric carboxymaltose. He has given an example of IPC along with the FCM. So that need to be, court should be enlightened. What is the difference between IPC and the
your
FCM?
turn will come, you
No,
enlighten.
no, no. You are giving example. You are giving
It's
example.
your application.
You justify it.
It's your application. No, those are-
Thank you. Counsel for the petitioner has concluded the argument. Yes, when? Petitioner 25. Petitioner concluded the argument. Let the matter appear on 23rd March at 3 p.m.
23rd March.
3 p.m. Nothing can be done.
No. My lord, your lordship has been very kind to us. But even though it, and the way your lordship takes noting, my lord, it is not very difficult for us to just go through that.
Thank you.